Yes, I. Them see where I come, Remember me tell you that. You see when me shot that video, yeah? A whole heap of big artists see it. I want to tell you, say, in my mind, God tell me, say, big artists, them say, how who the boy, yeah, man? How who him think him is? Boy, him a dress up like king in a video. Hey. Hey, make we blacklist him. Yeah, but also some of them bad mind artists and people thinking in the dancehall world and the music world, it full of politics and hatred and they ain't not even deep rooted like that. Some bad mind thing like they don't want to see a shine because them afraid to take certain position. You know, certain artists afraid to see a next artist get too big in a car. Then them not stop shining. You never know. We don't know that, right, people? Once a certain artist break out and everybody start loving him, and I guess what? Then forget about the next one, sometime now. Them not want that. So what them do? Them fight against him and make sure so them not say nothing about you. Them not share your thing. Make sure nobody not know him like that, because we want to use his style and go and pop off and with their whole 50-year-old self. Anyhow, people, that's another conversation for another time. Today we're going to talk about Mavado Son being free, and me get that download there from over Popeye them side. Big up to Popeye them and the whole media too. You know me I say what them do. Some of the things them definitely help if you know what go on before we even have to search for it, and them man just fling it out. Whoa, you know me I say? So respect to that, and we're gonna talk about that right now and make it play out. You see me? So big up all the people them were there. You don't know this one here is a kind of a replay, repost to who have to share the information, and we're glad to see Mavado Son free. We're happy because a young youth and him, every youth have a chance to live a life. I want to take the best options out there to live the best life and do the right thing so they can have a fulfillment, family, beautiful children. You know, the things that really matter. Instead of this little bragging and hype about gun business and badness. Them things they are garbage, brother. Trust me. It's a waste of time. Graveyard and prison yard, nothing beneficial night. That's just a bag of hype and talk for some people ignorant. Let's be real. Let's just be true for yourself, to yourself. Alright, let's go. Let's listen to what go on and how him get free. We're happy to see it. So I make that one rinse out, people. Until the next conversation, we'll just talk about, we're gonna bring that forward after this. Stay tuned for more. Make sure to hit that like button for me, please. You see me I say subscribe, hit that notification bell. Your feedback is important, fam. We respect it and we will definitely reply. See me? Yeah, man. Big up on yourself. Lovely day. Make all the vibes. Watch it.
Watch this video.
Time now. Time now. That's all God.
So by now, you must have heard that Mavado's son, Dantay Brooks, and his co-accused, Hinds, they were freed by the Court of Appeal on Friday, March 7. A lot has been said about this case, but in this video, what I'm going to be doing is tell you what the prosecution and the defense presented at the trial at the Home Circuit Court and the Court of Appeal. I'm also going to be giving you the reasons the Court of Appeal judges gave for freeing both Dantay and Andre. In this video, I'm not going to be giving you my opinion. What I'm going to be giving you is the evidence presented in court, the arguments presented, and what the Court of Appeal judges said. So, Dantay and Andre, they were tried in the Home Circuit Court by a judge sitting alone. There was no jury, and this was by mutual agreement between the accused and the prosecution, meaning this was not imposed. It was agreed by the lawyers for the Crown and the lawyers for the defense. The name of the judge at the trial is Mr. Leighton Pusey. Both Dantay and Andre, they were tried for 1. Murder, 2. Illegal possession of firearm, 3. Shooting with intent, and 4. Arson. On January 7, 2021, they were convicted for murder, illegal possession of firearm, and arson. On March 19, 2021, they were sentenced. Dantay Brooks, who was 18 years old at the time, he was sentenced to life imprisonment with the stipulation that he served 22 years before becoming eligible for parole. Hinds, he was sentenced to life imprisonment with the stipulation that he served 17 years before becoming eligible for parole. Now, the evidence against Dantay and Andre primarily came from a single eyewitness. His name is Lancelot Thomas, but he's popularly known as Lance, and he's the father for the guy who was killed. Lance, he testified that on the evening of Monday, June 4, 2018, about 6:30, he was walking to his home from a local corner shop while talking to his son, Lorenzo Thomas, also known as Israel, on the phone. He said during that time, Dantay approached him and tried to take away the phone from him. He said he pushed away Dantay, and after a back and forth argument between both of them, he left. Lance, he said he went and he spoke to his boss, then went home. He said later in the night, about 9 o'clock, he went out on the road to meet his son. On his way home, he saw Dantay and some friends near to his gate. He said about 11 o'clock in the night, his son came to the house. He said they spoke outside in the yard for a few minutes before going inside, where they continued talking. So let me pause right here for a bit, because many of you might be wondering, what was the father and son talking about? That would not be acceptable in evidence, because that would be hearsay. Are you following me? So the father, he said that he and his son, they went into the yard and through a crease in the zinc fence that fenced off his yard, he pointed out some persons to his son. The persons were Dantay, Andre, a girl named Zizi, and a guy known as Naka Naka. He said they went back inside the house. The father, he said early the next morning, June 5, about 3 o'clock, he and his son were in the house in separate bedrooms when he heard the front door of his son's room being kicked in. This was followed by a loud explosion sounding like a gunshot. The father said he got up out of his bed and he went to the doorway of his son's room. He said he saw his son clutching his chest as he fell to the ground. He said he then turned around and noticed several individuals standing inside his house. One of them had a handkerchief covering his face, positioned below his nose. He said the hoodlums pushed him to a spot in his room and a towel was placed over his head. He said the hoodlums instructed him to stay there and don't move. He said he removed the towel from his head, stood up and attempted to go into his son's room, but he was prevented from doing so by the hoodlum wearing the handkerchief. He said the hoodlum pushed him back into his room. The father said at that moment he heard a voice he recognized as Andre asking, "You not kill him?" He said he then heard a voice he recognized as belonging to Dantay responding and said, "No, Lance Nuffy dead." The father, he said after recognizing the voices, he stepped out of his room again. By this time, the person who was wearing the handkerchief had pulled it down. The father said he recognized it was Naka Naka. He told the court that he also recognized Dantay and Andre, whose faces he could see. He said Naka Naka pushed him back into his room, and by this time, his son, who was not yet dead, crawled into the father's room. He said Naka Naka pulled away his son. The father, he said he then heard gunshots and he saw when Naka Naka went and stood over his son's head. He said Naka Naka then asked for a cutlass, which was handed to him by Dantay. The father said he saw when Naka Naka repeatedly chopped his son. Listen to this part keenly now, because a lot has been said about who Dantay was talking about. I'm not going to speculate. I'm just here giving you the evidence that was in court. The father said he heard when Dantay Brooks said to Nakanaka, who was chopping his son Israel, that someone needed Israel's head. Nakanaka responded by saying, "You can't chop it off, you know." The father, he said Nakanaka then took a gun, pointed it at his son's head and squeezed several times. Nakanaka, he then asked for gas. The father, he said that Andre, he then took a bottle from a knapsack that the female named Zizi had on her back and handed it to Nakanaka. Nakanaka, he then sprinkled the gas all around. Some of the gas, he said, caught him, the father. The father said, Dantay, Andre and Zizi, they then left the room. He said, Nakanaka took out a lighter and set fire to the room. The father, he said he ran out of the house to a neighbor's house next door where he hid. He said he remained there until morning when the police came. He said he was taken to the Constant Spring police station where he gave a statement. Now, I'm going to be giving you some of the cross-examination of Lance by the defense lawyers later on as presented in the Court of Appeal. Stand by for that. So, the defense, they made a no-case submission on behalf of both Dantay and Andre, but the trial judge, he ruled that there was a case to answer on all counts except the case of shooting with intent. Both Dantay and Andre, they gave unsworn statement, meaning the prosecutor could not ask them any question about what they had to say. Dantay, in giving his evidence, he denied being at the scene of Israel's murder. He claimed that on the night in question, he was at home with his grandmother, his grandfather, and his brother. Dantay's stepfather, he also testified in court in support of Dantay's alibi. The stepfather stated that he returned home sometime after 1 o'clock in the morning of June 5, 2018. He said he saw Dantay at their home before going to sleep. Andre Hinds, in giving his evidence, he said that on the night of the incident, he was sleeping with his girlfriend and he was not at Israel's house. Andre's girlfriend also testified on his behalf. She said she arrived at Andre's house about 8 o'clock on the night of June 4, 2018. She said by 9 o'clock they were in bed. She said sometime after 3 o'clock the next morning, she was awoken by gunshot coming from outside. She said that after hearing the gunshots, she spoke with Andre, and then his aunt, who was in the passageway, called out to Andre. So that, in essence, was the case presented. Well, a lot more evidence would have been presented by investigators, crime scene investigators, pathologists, etc. The trial judge rejected the evidence of Dantay and Andre and accepted the evidence given by the father, Lance. The judge found Lance to be a witness of truth, and he found both Dantay and Andre guilty. So both Dantay and Andre, they filed appeals. Now, I'm not going to go into the grounds for appeal. What I'm going to give you is the submission by the lawyers supporting the grounds as filed. I am, however, going to be concentrating on two grounds because that's what the Court of Appeal concentrated on. The issue of identification. Dantay's lawyer argued that this case turns primarily on the correctness of the visual identification by the father Lance. He told the Court of Appeal judges that it was incumbent on the judge that tried the case to properly warn himself of the correctness of the visual identification by Lance, as opposed to the truthfulness of it. He said the trial judge failed in this regard. He argued that it was not sufficient for the trial judge to resolve the issue of identification by considering whether, in his opinion, Lance was a witness of truth. He said the judge had to go the added step of considering whether the identification of Dantay by Lance was accurate. The lawyer said the trial judge, in his analysis of the accuracy of the purported identification of Dantay by Lance, failed to examine the possible weaknesses in the evidence of Lance that could detract from the accuracy of his purported recognition of Dantay. The lawyer argued that this was a fatal error. He further argued that the trial judge's warning of the dangers of mistaken identity was not in accordance with the warning as recommended by a previous court ruling. As a result, it was woefully inadequate in relation to Lance saying he recognized Dantay's voice. The lawyer said that the trial judge did not give a specific indication of how the question of voice identification should be dealt with and did not demonstrate that he applied these principles. The lawyer referred to a case involving Donald Zeke's Phipps versus the DPP and the Attorney General, a Privy Council case in which the board proposed the appropriate warning that should be applied when the issue of voice identification arises for determination in a criminal trial. Andre Hinds also submitted several grounds for appeal, and his lawyers also made submissions to the court to support the grounds. Andre's lawyers told the Court of Appeal judges that the no-case submission at the trial ought to have been upheld by the trial judge. The lawyers highlighted what was described as a plethora of inherent inconsistencies, contradictions, and overall variances in the evidence from the father, Lance. He argued that it was incumbent on the trial judge to consider the quality and reliability of the evidence, which necessarily involved the court carrying out the assessment of the witness and the evidence. The lawyers said Lance undermined his own testimony, especially when the differences within and across his narrative are viewed cumulatively and in the absence of any other material to prove the prosecution's case. No jury properly directed could rely on Lance's evidence, and the no-case submission ought to have been upheld. The lawyers argued that the inconsistencies, contradictions, and variances in the evidence on the prosecution's case were not fully addressed by the trial judge. The lawyers highlighted the evidence of the attempt to take off Israel's head. They contended that this bit of evidence was not supported by the post-mortem examination report. The lawyers also said that Lance failed to identify Dantay and Andre when he had the first opportunity to do so, and according to them, this was not effectively resolved by the trial judge. They said that this was a matter that affected the reliability of the evidence of visual identification. The lawyers said the explanation that the trial judge accepted as being reasonable, which was that Lance told the police lies because he did not trust the police officers, was not reasonable on an objective assessment. The lawyers submitted to the Court of Appeal judges that the trial judge wrongly utilized the evidence of police witnesses. Those police witnesses spoke of the reluctance of persons to give evidence in some of these matters in support of Lance's explanation for his conflicting evidence. They said since none of these police witnesses gave evidence that the reluctance was because they thought the police officers at the Constant Spring police station are corrupt. The lawyer maintained that Lance's evidence that he was pressured to attend and give a statement at the Constant Spring police station was not credible when viewed objectively. The lawyers said because Lance was told to give a statement could not reasonably be considered to be pressure being brought to bear on him. They said that the purported identification of Andre was in terrifyingly difficult circumstances. These included poor lighting in the early morning hours and the distance of the veranda light to the face of the person identified as Andre was not ascertained. They argued that these and other difficult circumstances, including the fact that Lance had seen his son being killed, were not adequately addressed by the trial judge. So, here is how the Crown responded to the lawyer's submissions in relation to the issue of voice identification. Now, you remember that Lance, he had said that he recognized Dantay's voice. The Crown admitted that the prosecution did not elicit the necessary evidence of Lance's knowledge of and familiarity with the voice of Dantay, which the authorities dictates must be present before voice identification can be utilized. As a result, the Crown conceded that the trial judge made a mistake in relying on the evidence of voice identification. The Crown, they initially advanced the position that the trial judge adequately warned himself of the need to assess evidence of visual identification with caution and of the necessity to bear in mind a previous Privy Council ruling known as the Turnbull Guidelines, where the prosecution relies on the correctness of visual identification. The Crown acknowledged that there was no explicit statement by the trial judge regarding honest witnesses being mistaken or the fact that miscarriages of justice have occurred due to mistaken identification. However, it was contended in the Crown's submission that despite this omission, the statement of the trial judge of consideration of the Turnbull Guidelines can reasonably be taken to include the full gamut and range of the Turnbull Guidelines, which is inclusive of the warnings and factors. The prosecution, they later conceded that the trial judge did not demonstrate that he applied the Turnbull factors when he examined elements of Lance's evidence, such as his prior knowledge of Dantay and the opportunities he had to observe the attackers. And talking about the Turnbull Guidelines, the main portion of the judgment at which the trial judge refers to the Turnbull caution and on which the Crown initially relied at the Court of Appeal until it conceded is this. The trial judge, in his summation, had said this: I go back to the evidence of Mr. Lancelot Thomas. This is a case then which, if I accepted that Mr. Thomas was there, the question then comes to the issue of identification through recognition. I consider the fact that I give myself the necessary Turnbull caution, namely, the fact that I needed to consider his opportunity to see, the knowledge he had of these persons, how recently he saw them, the questions of how the circumstances were. In this particular matter, the evidence is that he knew both of these gentlemen very well in the community. He indicates, and I accept, that he saw them shortly before the incident, looking through the fence. I accept that there is a light there and he could see them at that particular time, and that he had seen them earlier in the night. I accept that the circumstances in which he saw them inside the house were not difficult circumstances. I accept that, as Mr. Thomas says, there was a light on the veranda and he was able to see them. I accept his indication of seeing them for what he called 2 minutes. I note that there were some discussions in relation to 2 minutes or 7 seconds or 7 minutes. I note that the estimation of time is always difficult for witnesses, as it is for all of us who try to do that without a clock. Mr. Thomas was very clear that he saw these particular persons, and although at least one of them was trying to dance him or avoid him, he was able to see them. He indicates that there was also voice recognition, that he recognized the voice of both of them, and these were persons that he knew. In fact, one of them is his near neighbor, and the other person was somebody he had seen and spoken to the evening before. Now, the Court of Appeal judges, they ruled that they were of the opinion that the trial judge's reference to the Turnbull caution and what it should entail did not adequately convey the importance and full tenets of the warning, the necessity of which arises from the inherent and serious risks associated with visual identification evidence. The Court of Appeal judges, they emphasized that the trial judge's caution and the specific reference to Turnbull was in the following terms. This was what the trial judge had said, and I quote, "I consider the fact that I give myself the necessary Turnbull caution, namely, the fact that I needed to consider Mr. Lancelot Thomas' opportunity to see, the knowledge he had of these persons, how recently he saw them, the questions of how the circumstances were." Now, the Court of Appeal judges, they ruled that they did not accept the submission of the Crown that the statement of the trial judge referencing the Turnbull guidelines was sufficient to satisfy the duty imposed on him by law to give sufficient expression of the legal and factual considerations which underpinned the verdict. The judges said, "It is important to bear in mind that Lance was the only eyewitness. He gave a narrative of the events leading up to the killing of his son. But in relation to the identification of Dantay and Andre at the time of the incident, it is important to highlight some key elements of his testimony. Lance stated that when he was at the door to his son's room, he saw Dantay, Andre, and ZZ. At that point, Andre was about 6 feet from him as estimated by the court. In relation to the length of time during which he observed the faces of Dantay and Andre, Lance told the court that he saw Dantay standing behind Naka Naka. Naka Naka was within Lance's reach. He said he looked at the face of Dantay and realized that it was him. He said he stared at both of them and him take one stone to kill two birds, at which time he saw Dantay's face for about 2 or 3 minutes. He said he did not see ZZ at that point because she had not come into the room as yet. In cross-examination, Lance, he was challenged with the statement that he gave the police on June 7, 2018. In that statement, he said, "At the time I looked around and recognized Dantay was about 7 seconds. He responded by saying he had said 7 minutes, but it was the police who wrote 7 seconds. He confirmed under questioning that he would not have said 7 seconds since it was more like 7 minutes. The Court of Appeal judges said that they acknowledged that the trial judge did analyze some of the essential matters in his attempt to determine whether the evidence of Lance concerning his ability to identify Dantay and Andre was reliable. However, the Court of Appeal judges, they agreed with the submissions of the lawyers that the trial judge did not give sufficient weight to the possible weakness of the identification evidence caused by the poor lighting in the early hours of the morning. Having regards to this issue and the reliance on lighting from the veranda, the distance of the light source on the veranda from the faces of Dantay and Andre at any point was not ascertained. Lance said he had electric light on the veranda and he could see Andre's face from the reflection of the veranda light because the door was wide open, but the relative position of the door in relation to Andre was not ascertained. The trial judge, in his summation, he stated that he accepted as Lance stated that there was light from the veranda and he was able to see them. The Court of Appeal judges, they said that there was no objective analysis of the adequacy of the lighting which provided a reasonable basis for accepting Lance's assertion in that regard. They said the trial judge did not sufficiently address the terrifyingly stressful circumstances under which Lance purported to identify Dante and Andre with his son being killed before his eyes. Are you following? I hope you are not bored. I hope you are learning something because there is more to come. So the Court of Appeal judges, they said that an equally important issue that impacted the trial judge's acceptance of the identification evidence was his treatment of the credibility of Lance, having regard to the inconsistencies in his evidence. The lawyers meticulously identified and highlighted numerous inconsistencies in Lance's evidence. Chief among these were his evidence relating to the identity of his attackers and what was advanced by one of the lawyers to be discrepancy between Lance's evidence of the attempt to take off his son's head from his body and the scientific evidence stemming from the post-mortem report. Lance admitted in his evidence in chief in his first statement, which was made at the Constant Spring Police Station on June 5, 2018. He said the attackers had unmasked, but that was not true because they did not have on any, although he testified in examination in chief that Naka Naka initially had a handkerchief covering his nose that he pulled off his face and placed under his chin. He also admitted that he lied when he said it was 4 males and not 3 males and a female who entered his house. He explained that he did not speak the truth in his first statement because he was afraid due to the Constant Spring Police Station being a corrupt station and he knew of incidents there as a result of having done construction work there. Lance, he gave a second statement on June 27, 2018 at the Spanish Town Road Police Station and he admitted during cross-examination that in that second statement he said in relation to the June 5, 2018 statement that he was pressured to say certain things and I was then pressured to sign it. One major point taken by the lawyers at trial was that Lance did not identify the attackers on the first reasonable opportunity when he had an opportunity to do so at the Constant Spring Police Station. The trial judge considered this omission and arrived at the following conclusion. This is what the trial judge had said in his summation. When I take into consideration the witness evidence, when I take into consideration the circumstances of the case, the circumstances of the statement, I accept his evidence that he told untruths at the police station, the Constant Spring Police Station, in the first statement because he did not trust the police officers. I accept his evidence in relation to that. I thought it would be something which was reasonable and it was supported by the evidence of some of the police officers who spoke about the reluctance of persons to give evidence in some of these particular matters. I didn't find Lance to be a witness that, despite his defensiveness in terms of cross-examination, was trying to mislead the court in any way, and I found that all in all he was a witness of truth and that his evidence will be examined to see whether or not they were made out. The Court of Appeal judges said there is a clear distinction between, on one hand, telling untruths because one does not trust the police, and on the other hand, being pressured to sign the statement containing those untruths. They are of the view that the trial judge did not adequately explain why he accepted the first explanation as reasonable and, by extension, credible in light of the alternative and contradictory explanation also coming from Lance of him being pressured. Furthermore, Lance did not provide any other explanation for giving conflicting statements to the police. The trial judge used the evidence of some of the other police officers to accept Lance's explanation for the conflict between the police statements and his evidence at trial concerning the identity of the perpetrators, that he did not trust the police officers. At no time did the police witness say that the reluctance of persons generally to give information to the police emanated from their beliefs that the police at the Constant Spring police station are corrupt. The approach of the trial judge in advancing an explanation in supporting of Lance's conflicting evidence that did not, in fact, support the explanation accepted by the trial judge is indeed objectionable. Therefore, the Court of Appeal judges agreed with the submissions of the lawyer that the trial judge made a mistake in this regard. They also stated that the existence of many inconsistencies and discrepancies in relation to Lance's evidence was acknowledged by the trial judge when he said this in his summation. The judge had said, "I have to consider in all these matters the evidence of witnesses and the reliability of the witnesses in the case, and in so doing, I will look at the demeanor of the witness, how the witness gave evidence in the witness box, the fact that he was led in chief and he was cross-examined extensively. In particular, the main witness by the lawyers for the defense. I have considered the differences, the inconsistencies, and discrepancies in his evidence between things that he said in the various statements that he has given and things he had said in the witness box. I do agree that the court ought to look carefully at the evidence of the sole eyewitness and the circumstances of this particular case, where there is only one person and there are some differences in his evidence. The court has to look at it in a great deal of care to see whether or not the court is convinced of the evidence of this witness. So I go briefly through the evidence of Mr. Lance Thomas. The Court of Appeal judges, they said that they agreed with the submissions for the lawyers for both Dante and Andre that the numerous discrepancies in the evidence of Lance generally required the trial judge to demonstrate a careful analysis of his evidence when considering his credibility and reliability generally. This amplified the need for the trial judge to demonstrate that he had specifically resolved the inconsistencies and discrepancies in relation to the visual identification of Andre and Dante in particular. They concluded that the trial judge failed to adequately do so. An additional issue in the case was voice identification. The Court of Appeal judges, they said that the prosecution was correct in conceding that the evidence of voice identification should not have been admitted by the trial judge because the requisite foundation for its admission was not laid. The added complication and risk of injustice caused by its admission is that the evidence of purported voice identification was used in support of visual identification. Are you following me? The trial judge had said this in his summation. I found that Lance Thomas, he saw the attackers. I found that he had ample opportunity to identify Dantay Brooks and Andre Hinds, that he identified them both by voice and by sight. I find that they were parties to the action of the group that attacked Mr. Lorenzo Thomas. The Court of Appeal judges said that this improper use by the trial judge of voice identification to bolster visual identification of Dantay and Andre further supports their conclusion that the conviction of Dantay and Andre was unsafe in all the circumstances. The Court of Appeal judges, they concluded that they were of the view that the failure of the trial judge to adequately warn himself of the dangers inherent in identification evidence, combined with the deficiencies in his treatment of the identification evidence and matters going to the credibility of Lance the father, resulted in both Dantay and Andre being deprived of the safeguards developed by the law to prevent ghastly risks of conviction on unreliable evidence of identification. The Court of Appeal judges, they said that in the circumstances of this case, the convictions of Dantay and Andre are rendered unsafe, leading to a substantial miscarriage of justice. Accordingly, there is a justifiable basis for the Court of Appeal to quash their convictions and set aside the sentences imposed by the trial judge. The judges said, the Crown, having candidly accepted that the trial judge made a mistake in treating with the evidence of identification and the conflicts in the evidence of the prosecution's main witness, which critically affected his credibility and reliability, has quite rightly not argued for a retrial. The judges said, for the reasons expressed, they made the following orders. 1. The applications for permission to appeal conviction and sentence are granted. 2. The hearing of the applications for permission to appeal is treated as the hearing for the appeal. 3. The appeals are allowed. 4. Dantay and Andre's convictions are quashed and their sentences are set aside. 5. Judgment and verdict of acquittal is entered in respect of both Dantay and Andre. Blessed love, everybody.
Yes, people, so you hear it clearly right here. Dantay Brooks, the son of dancehall artist Mavado, yeah man, beat the murder charge because of all of the things that were going on within the trial and evidence and such. You know what I mean? I say, yeah man, the man beat the murder charge right there, so, and him friend also beat it. So basically, them gone home and now free up. And the great thing about that is that, you know what I say, the people who are responsible for this might just be in the win. For real. And it's a mix-up thing. So everything we're going on is just like a point finger, like a them did, them did. But when them really check out everything, them really realize, hey, you know what? Them have to quash this thing. Jano. Them know them reasons. I don't have to ask them people. It's not me. This is not my case. It's not my doing. It's not my action. Everything I say is from particularly what's read inside out when you hear it for yourself. So, yeah man, we just want to play that for people who don't hear it yet, who never know now. Say, yeah man, Mavado Son, this is the reason why I'm in beat the murder charge. This is the reason why I'm get off. Life in prison is why I'm did facing up people. Serious. So, we're happy if you know, say, you know, I say it work out and, you know, we don't want to see a murderer go free, you know, but if a youth innocent, enough innocent you in a prison right now for things what them never do. We want to know that, so. However it may be, Almighty Creator know the best. So I say people, so when you just stay tuned for more. I just want to get that one out of the way because we don't want to make people know what's going on with this. Enough people don't know. So yeah man, stay tuned. Make sure to subscribe to the notification bell. Definitely leave your feedback and like the video. Please stay tuned for more Reasoning with G Terry. You see me? No schooling outside.
Nice.